Uh, well, good morning. Merry Christmas to everyone. I've got my Christmas sweater on there. So today I'm going to be providing another daily update on the California Board of Psychology hearings that are coming up starting Monday. And there was some changes on Friday. In a pretrial hearing, the administrative law judge heard the state's motion in limine, and mine as well, and they granted the states to a degree, and then overruled mine or didn't grant mine, and I filed an objection that documented that into the record or maintains that for the record for appeal. But I was asking for a baseline of evidentiary standards that would involve judicial notice of an obvious, undisputed fact that parental alienation and PAS are not in the DSM-5, and that we have evidentiary standards that are consistent with the APA Ethics Code 2.04 and 9.01. That was overruled, denied. So now I have to prove that something that doesn't exist, because and so that's involved a whole reorganization of my defense over the last few days. So I'm going to talk about that today. So the first, as I was saying, when my motion in limine for evidentiary standards was not granted, I objected to preserve the record for appeal. And I am now forced to admit evidence to prove that a non-existent thing, parental alienation, doesn't exist, and that this will, of necessity, take time away from my defense related to the situation of institutional and regulatory capture that is relevant to my standard 1.05 obligations. And I will be spending my precious defense time proving the obvious, that parental alienation is a violation of standard 2.04, triggering my 1.04 and 1.05 obligations. And so essentially what we have in this case, and you'll hear this on my opening arguments as well, is we have a conflict between ethical standards. So the state is relying on the collegiality standards to behave nice in the sandbox, basically, with the other professionals, whereas the defense is relying on standards 1.04, 1.05 that have to do when there's an ethical violation by another psychologist, we have to take action. And 1.05 says that we take further action, quote unquote, appropriate to the situation, which then requires what is that situation, which then requires a defense to elaborate on what that situation is. The difficulty here now is that while parental alienation, PAS, are obviously fabricated, they are obviously in violation of 2.04 bases of scientific and professional judgments, which make them also then in violation of 9.01 bases for assessment, 5.04 media presentations as they spread this fabricated information across globally, and 3.04, avoiding harm. And so that's obvious, okay, for the parental alienation syndrome, parental alienation, it's obvious it's in violation of 2.04, 9.01, 3.04, and as they disseminated, 5.04. However, because of that ruling on Friday, I'm now going to have to prove the obvious, because then I need to also prove that the situation or demonstrate the situation, the context in which my decisions were made. And so now I had to rework everything. It's because I can no longer solely focus on the situation that was the context for my actions and have to prove that parental alienation doesn't exist. So, as I said, I objected and, you know, and asked to preserve the record for appeal because I think this is a violation of my due process rights to present a fair defense because I have to prove the obvious. For 40 years, it's never been in the DSM. It's just fabricated information. And 40 years later, I need to go back and do a whole thing about parental alienation, which is exactly the problem in the family courts. Everybody's arguing whether or not parental alienation exists. No, it doesn't. Apply the DSM-5, you have an immediate diagnosis, shared delusion, factitious disorder, child psychological abuse right away. The very moment we apply the DSM-5, we get that diagnosis. This thing, parental alienation, does not exist. And so that's a violation of 2.04, and then they promulgate it everywhere, and that's a violation of 5.04, and then that activates my obligations to do something about it. And so anyway, we have that on record. But it's meant that I've had to reorganize everything over the weekend, and I was getting new exhibits and things into the state to meet the discovery deadline of yesterday. But I got, I think, most everything in. I may have forgotten an exhibit or two that I wanted to use for my my direct examination of my witnesses, because I was trying to get so much all put together for the cross-examination of their witnesses relative to parental alienation doesn't exist. So, so I had to redesign the defense. The administrative law decision required a complete redesign of my defense away from 1.05 in the situation over to proving the 2.04, 9.01, and 3.04 ethical violations. So I redeveloped all my exhibits, deleting some, adding others. Today, hopefully, I'm going to get those up on my website, the new set of exhibits. And my defense exhibits are now tailored to cross-examination, presenting the evidence that parental alienation, PAS, is a fabricated pathology in violation of 2.04, that is harming children and their parents, a violation of 3.04, and degrading the court's decision-making surrounding the child, 9.01, which is exactly what's happening here. It's degrading the quality of the information to the court, or to the administrative law judge until I correct that record, and until I elevate the standards that we are applying. So this is one of the new exhibits. It's from Joan Meyer. She's a George Washington University law professor. She's a professor in clinical law, and she's the director of the National Family Violence Law Center at George Washington. Now, interestingly, my son went to George Washington, but this is a long-standing critic of PAS, almost from the beginning. She was a very vocal and substantial critic of PAS, and I will be introducing evidence as to why that is. Why is she critical? And basically what we have with this pathology in the family courts, a child rejecting a parent, it's child abuse by one parent or the other, because that's the only thing that produces that symptom. A child trying to flee from a parent, that's child abuse, either by the targeted parent, which is the path A, or it's by the allied parent, which is path B. That's the delusional thought disorder, factitious disorder, and psychological abuse. So one way or the other, it's abuse. Now, what Joan Meyer is worried about is that this parental alienation PAS, especially when it was initially introduced by Richard Gardner, is going to result in the path A abuse, because it's in her case, the pedophile parents, the pedophile dad, when he's accused of sexually abusing the child, is going to say, "No, I didn't. It's parental alienation. It's the mom's influence." Okay. And then these children will be returned to these narcissistic dads. The other is that there's been a history of spousal abuse by the narcissistic father that's resulted in the child's fearful rejection of that parent. And then the parent dad says it's parental alienation and gets around the spousal abuse. And so that's her argument. Now, I am on the other side. I am saying that the problem is it covers up the child abuse by the allied parent, because instead of diagnosing the delusional thought disorder, factitious, everybody is talking about parental alienation, and they're not using the word child abuse. So the courts and the other litigants don't know it's child abuse, and they're withholding that diagnosis from the targeted parent and their attorney. And so it's harming them, the targeted parent, and the child on the path B. Joan Meyer says it's harming the children and the protective parent, target or protective allied parent on a path A. So both sides of the issue are saying that parental alienation is leading to the abuse of the children. Okay. And so I'll be presenting the evidence from early PAS regarding the concerns. Now, with Dr. Burnett, he was an early collaborator with Gardner. And so that I'm going to put them both together. And then Gardner committed suicide, and Dr. Burnett continued on advocating for parental alienation syndrome, then switched it around to parental alienation, dropped the syndrome because that was just had way too much baggage and was way too unsupportable. So they say, well, it's not a syndrome, really. It's just a set of symptoms, kind of, maybe. And so I'll have to go back and present all that from the beginning. What is parental alienation syndrome? What is PAS? Why isn't it? And all this sort of thing. But I'm going to rely on Dr. Meyer, or Joan Meyer here, for some of that. And so here's the exhibit that I will be seeking to introduce. It's an essay from Joan Meyer, the law professor at George Washington, from 2013. Now, 2013 is the period of the DSM-5 when they were coming out. And so it's parental alienation syndrome and parental alienation, a research review. So I figure if I'm forced to prove that parental alienation and parental alienation syndrome don't exist, then I'll turn to like a respected law professor who does a research review on the supporting evidence for it. And so that's one nice, concise place to put it all together and put what the objections are in that. And it's 2013, so it's right around the time of the DSM-5 judgments about, and Burnett and his little group, his PASG people, were putting together their advocacy for inclusion of parental alienation into the DSM-5 somewhere. So here's what some of the quotes that Ms. Myers, Professor Meyer, says in her article. Richard Gardner, a psychiatrist loosely affiliated with Columbia Medical School, who ran a clinical practice that focused on counseling divorcing parents, based solely on his interpretation of data gathered from his clinical practice, Gardner posited that child sexual abuse allegations were rampant in custody litigation, and that 90% of children in custody litigations suffered from a disorder which he called parental alienation syndrome. Now, are there false allegations of sex abuse? Yes, and that typically shows up on the borderline variant. So the borderline parent will, and a delusional disorder, they'll get the child making these false allegations, a shared delusion. That happens. Is there true sex abuse? Yes. Will pedophile, sex-abusing fathers or stepdads use parental alienation as a defense? Yes. They'll say, oh, no, it's fabricated and this is all just created by the mother. And that clouds the issue. If we rely on the DSM-5, however, or DSM-4 back then we get an immediate, we can have a way to assess for the delusional thought disorder and the borderline. So if it's a false allegation, it's going to be a persecutory delusion. You can do a mental status exam with the mom and you can pull out the persecutory delusion, and you can do a modified one with the child and it's delusional disorder. And so you actually have assessments that can document that's a delusion. And when you go to the allied parent on an authentic abuse situation, you'll find that they're not delusional. They're fine. They're a normal range mom in that situation, or potentially a dad. But typically it's a borderline spectrum that has the false allegations of abuse. Now, the other interesting thing, though, is that Professor Meyer here is only talking about the sex abuse of the path A, and she's for women, domestic violence, violence against women. She's not talking about the narcissistic dad pattern in which a narcissistic father is using the child as a weapon of spousal abuse against the mom. And so she's the violence against women, but she's entirely missing a whole category of violence against women. Why? Because everybody's worried and focused on parental alienation syndrome rather than the delusional thought disorder or the narcissistic and borderline. We have two variants. We have basically the narcissistic dad pattern, and with a normal range mom, and we have the borderline mom pattern with a normal range dad. So it's gender equal. But Gardner was kind of off on his sex abuse kind of thing, and his mission to protect or to discount sex abuse allegations. And so he focused only and recognized only the borderline mom pattern, didn't recognize the narcissistic dad pattern. Now, again, he's a psychiatrist trained in medical school. He's not necessarily trained in attachment pathology or family systems, but he should recognize a delusional thought disorder. Oh my goodness, it's in the DSM. So he should have recognized narcissistic borderline personalities were in the DSM. He just left the DSM to make up his own stuff. So another quote from Professor Meyer: while Gardner and PAS have had many adherents, Dr. Burnett, particularly among forensic evaluators and litigants, there is actually no empirical research validating the existence of PAS, and there is extensive empirical proof that the assumption underlying the theory are false. And so there's no empirical support. And this is 2013, it was proposed in 1985, roughly. And so this is like 25 years later. There is no empirical research supporting it. It's not a real thing. It's a fabricated pathology. So PAS has been rejected multiple times by the American Psychiatric Association as lacking in scientific basis. There's your violation of 2.04, bases for scientific and professional knowledge. Right there, boom, has been rejected as lacking scientific basis and therefore not worthy of inclusion in the DSM and the Diagnostic Statistical Manual of Mental Disorders. There's your violation of 9.01. It's not based on information sufficient to substantiate its findings. So the most recent all-out campaign by PAS proponents for inclusion of the renamed parental alienation disorder was flatly rejected by the DSM-5 committee in 2012. So when the evidence comes forward, there's an email now, which these PAS proponents, that's Dr. Burnett and his collective parental alienation study group and his whole group. And I was in the group, and they're putting on this major effort to get PAS or parental alienation accepted somehow into the DSM-5. And she's right, it was flatly rejected. Now, interestingly, she cites to 2012, and that's consistent with the email he sent out that they knew it wasn't going in as an independent diagnosis in the DSM-5. No way. Okay, it's just getting up with ADHD or those sorts of things. Nope, not happening. The limited goal of these self-proclaimed PAS experts, this Dr. Burnett and his group, was to simply get it mentioned somewhere. Just mention it in some place. And that's all they were seeking, and that's what the email will show. And then when they didn't, when the DSM-5 rejected it in 2013, it was published, then the email, Dr. Burnett tells everybody, well, it's also a delusional disorder and a factitious disorder and child psychological abuse. So he knows what it is in the DSM-5. He's just not telling anybody because he's promoting himself. And that's the violation of 5.01 media presentations. And so that'll be interesting when I present that information to Dr. Burnett, ask for his opinion about Professor Meyer's findings. So now here's where it gets disturbing. And unfortunately, I need to go back to all the way back to 1985 and parental alienation to show why it's harmful, so harmful to children. Regarding pedophilia, Gardner argued expressly that adult child sex need not be intrinsically harmful to children. Let me stop there and really emphasize that. So Gardner, this guy who developed parental alienation, said sex abuse is not harmful to children. Okay. You know, can you imagine what that would do to the sex abuse advocates or the protection advocates who are saying, what are you saying? The sex abuse isn't harmful to children. I mean, that's just like ludicrous. And so it created so much controversy. Everybody's focused on this parental alienation syndrome and fighting about it. And that's where Professor Meyer comes in. She's saying, no, the sex abuse and pedophilia is wrong. Okay, it's not harmful to children, and it's beneficial to the species insofar as it increases a child's sexualization and increases the likelihood that his or her genes will be transmitted at an earlier age. Okay, that is significantly deviant from professional standards of practice and understanding. So Gardner is, I would say, clinical terms, off the rails. Okay, he's just totally saying pedophilia is okay and it's kind of normal, and we got these women who are making these false allegations, and even if it's a true allegation, it's not that bad, and so that's the origins of this controversy that now in 2025, 40 years later, we are still arguing about. It's time to put it to bed. Put it to rest. No, it doesn't exist. Despite his assertions that pedophilia is widespread and harmless, he asserted in a filmed interview that a child who tells his mother he has been sexually abused or sexually molested by his or her father should be told, quote, I don't believe you. I'm going to beat you for saying it. Don't you ever talk that way about your father. That's not what we do when a child says they're being sexually molested by their parent. Okay, that is not the response. I'm going to beat you for saying that. Don't ever say that about your father. So can you understand in 1980s and 90s why there was such controversy around this construct of parental alienation developed by this one psychiatrist who has significantly deviant views around sex abuse and pedophilia? And then he commits suicide. And then his adherents, Doctors Burnett and Larandos, and this small little collective of self-proclaimed PAS experts, continue on promoting this parental alienation syndrome and try to distance themselves from some of the more distasteful comments of Gardner. Now, the other evidence I will seek to introduce relative to my cross-examination with Dr. Burnett is going to be from the Leadership Council on Child Abuse and Interpersonal Violence. And it says, they're staunch opponents of these PAS experts as well. Now, to a certain extent, they're kind of, I suspect, a little more on the borderline mom, flying monkey kind of area. But this particular site, and you can Google these stuff, it's available. This particular site has all the quotes from Gardner about sex abuse and pedophilia. And so that's what their criticism is. So, Dr. Burnett, when you were back working with Richard Gardner, were these his views about pedophilia? Okay. What are your views about Gardner's views about pedophilia, since you support his parental alienation and you were back there at the time supporting him? So what are your views on this, Dr. Gardner? So here's what Gardner said. Children are naturally sexual and may initiate sexual encounters by seducing the adult. No. Children do not seduce their father into being a pedophile. That doesn't happen. That's a significantly deviant idea of Gardner's. Now, Burnett was his colleague. So, Dr. Burnett, what do you think? Was he off the rails a little bit on that? From Gardner, he has helped to for the pedophile parent. What Gardner recommends how to address the pedophile father is that he be helped to appreciate that even today, pedophilia is a widespread and accepted practice among literally billions of people. And that the father has to appreciate that in our Western society, especially, we take a very punitive and moralistic stance towards such inclinations. And he has a certain amount of bad luck with regard to the place and time he was born, with regard to the social attitudes around pedophilia. Okay, he's a sexual abusing pedophile of his child, and that's just his bad luck because we don't like it in our Western society. But it's normal, and so it's not really a bad thing. It's not very harmful to the child. Gardner argues or indicates that the removal of a pedophiliac parent from home should only be seriously considered after all attempts at treatment of the pedophilia and rapprochement in the family have proven futile. And that's from Sex Abuse Hysteria, Salem Witch Trials Revisited. So what Gardner's saying is, if the father has sexually abused the child, we shouldn't remove the father from the household, but we should try therapy and see if we can rehabilitate the father. And only if he continues to sex abuse a child and he's not, then we should consider removing the father. No to your PAS, no to your ideas, no to it all. No. And it should never have gotten off the ground. It should never be 40 years later, Dr. Childress is having to prove this is a harmful thing and it doesn't exist. It apply the DSM-5, please. So, Gardner, there is no question that abuse cases are turn-ons for a wide variety of individuals involved with them. The accusers, the prosecutors, the lawyers, and the judges. Wait, they're all getting turned on by the evaluators, the psychologists, the reporters, and the readers of newspapers, and everyone else involved, except for the falsely accused and innocent victim. Everyone is getting their jollies. That's the guy who came up with this parental alienation syndrome. Okay, that's his belief system, that the pedophiliac dad, even if he abused a kid, it's not that harmful, and we should try to treat it within the family, and because we don't want to, you know, it's just his bad luck that we view pedophilia so harshly, and that everybody else, all the judges and evaluators, they're just getting their jollies about promoting this sex abuse thing, and the poor victim of the pedophile father is just, he's the victim? Wait a minute, wait a minute, wait a minute. So can you see where Joan Meyer is kind of, whoa, stop, 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 stop. This is really, really bad. And so she did that early in the 80s and 90s, and then they did a little shell game and they said, we're not going to call it alienation syndrome anymore. We're going to call it just parental alienation. And she's still going, no, stop it, stop it, stop it. 40 years later, stop it. And that's what's responsible for Caden's law. If you want to know Caden's law, but I bet it's coming through violence against women here. Now, here, get this. Judges, too, may have repressed pedophiliac impulses over which there is suppression, repression, and guilt. Inquiry into the details of the case provides voyeuristic and vicarious gratifications to the judge. Incarcerating the alleged perpetrator may serve psychologically to obliterate the judge's own projected pedophiliac impulses. Richard Gardner is off the rails. Okay. He's saying the judges have pedophiliac impulses, and that's why they're so concerned about the pedophiliac dad. And it's not that. Stop it. Stop it. Stop it. DSM-5. Apply the DSM-5, American Psychiatric Association. We're looking for either authentic child abuse by the targeted parent. That's what Meyer is worried about. The pedophilia or physical abuse or some authentic abuse by that parent that's causing the child to want to flee that parent. That's path A. Or it's path B. It's a false or factitious attachment pathology being imposed on the child by creating a shared persecutory delusion. Both major psychiatric disorders, both diagnosable, and either one or both lands on the diagnosis of child abuse, child psychological abuse. So we have authentic abuse on one path, we got psychological abuse on the other path. That's the only thing that causes it. Apply the DSM-5, please. But by continuing to promote this parental alienation, it just throws the field into chaos, and it hides the child abuse. It hides the child abuse on path A. It hides the child abuse on path B. It hides all of the child abuse occurring in the family courts. So all of the child abuse in the family courts that's not being identified can be laid directly at the feet of these parental alienation experts, and they're continued to promote this, which is a violation of 5.04 media presentations. And so I'll deal with all that when we get to the hearing. But I just wanted to give you the background of what we're talking about with parental alienation syndrome, and that later evolved into parental alienation. It comes from a very dark place, and from one person's, Richard Gardner's, very unstable perceptions. Okay. And he gave himself permission as a psychiatrist. He gave himself permission to not apply the DSM-5 and to just make up his own pathologies that are grounded in very ideas that are highly deviant from the rest of clinical practice and society. So now let me just take a second here to cleanse what we've just talked about and return to established knowledge with this. And so another bit of evidence I will seek to introduce is this article, Attachment Goes to Court, Child Protection and Child Custody Issues from 2020. Okay. Now look at that. Do you see that big block of names there? Those are the authors of this article. If you look at that, I look at that, those are your top tier attachment researchers. Okay. And they're writing in the journal Attachment and Human Behavior. So they're not being requested to write a report or do something like that. They are voluntarily coming together as all the attachment researchers and publishing in their journal, Attachment in Human Development, Attachment Goes to Court, Child Protection and Child Custody Issues. Just recent, 2022, that a child rejecting a parent is an attachment pathology. It's a problem in the love and bonding system. The attachment knowledge is directly relevant to that. Now, what this article mostly discusses, because these are researchers, and the research is with young children ages 0 to 5, they're not researching stuff in the court. They're not in the family courts. So they're just giving attachment knowledge and saying, this is attachment knowledge, and so don't start misusing it in the family courts. Now, what the recommendation is that we need to get high-level attachment people in the family courts. And guess what? That's me. Okay, I am one of these people. Okay, now they're all researchers. I'm a clinician, but look at this clinical background. I have early childhood mental health specialization, 0 to 5, just like all of them, except I'm not in a university doing research. I'm in the foster care system doing treatment. So I have formal training in attachment-related pathology with Dr. Marie Polson at CHLA, a nationally recognized expert in early childhood psychology. So I have direct training from top early childhood mental health professional in 0 to 5 early childhood attachment. I know 2 additional diagnostic systems, 2 specialized early childhood diagnostic systems, DC 0 to 3, that's stronger in diagnosing attachment, and the DMIC, that's stronger in diagnosing autism. I know 2, I've been trained in 2 evidence-based attachment-focused interventions. Watch, Wait, and Wonder for infants, and Circle of Security for preschool-age children. And I have direct clinical experience as a clinical director for a multidisciplinary assessment and treatment center serving children ages 0 to 5 in foster care. And what I didn't put on there is I also have infant certification in infant mental health. And so I am a top tier expert in the attachment system and attachment pathology. So when you go back for a second to these folks, I'm spot on right with them. Okay, I'm just on the clinical side, and all these folks are on the research side. Okay, that's the only difference, but I am absolutely within this group. And I'm in the family courts. Then they're not. 15 years in the family courts, so I know exactly what's happening over here. So with that, I'm going to wrap up my daily talk today because I got more work to do. I have to prepare for the hearing, plus I got to go through a custody evaluation and another matter. Speak about that custody evaluation drops right into my prep time here, but I have to do an analysis of a custody evaluation for an upcoming case. Now, typically a custody evaluation to do that would take me weeks, 3-4 weeks to go through it line by line, do everything. I'm going to use Gemini 3, and Gemini and I are going to do the analysis. I hope to get it done today and get it to the client parent by this evening, the Gemini analysis. I'm going to have to wait till after the hearing to write the report because I just simply won't have time. But he's kind of under some deadlines and stuff. But that should work out to get him and his attorney the Gemini analysis by the end of today. And so AI is great. Let me tell you, I can do this in a day and get all that information over to their attorney and stuff, and for the cross-examination of the custody evaluator. I think it's going to be really helpful in the family courts. So with that, I'm going to sign off for today. Kind of Merry Christmas to everybody. I'll be talking to you tomorrow. So about the daily updates. Tomorrow is when I hope to focus in on my opening arguments and and cross-examination lines of questions and stuff. And then I'll keep doing that through the weekend. So with that, good luck, everybody. Take care. Promises to be a very interesting time over the next few days. And so good luck to everybody. Take care. Bye-bye.